Hello everyone, welcome back to our channel Law in Motion. Imagine this. In a world where almost every action, every transaction, every conversation is digitally recorded, do you truly have the right to privacy? Or is your personal life just another open book, vulnerable to anyone who chooses to read it? What if I told you that in India, this very question became the battleground for one of the most critical legal cases of our time? One historic case, where the stakes were nothing less than our right to live privately, unseen and untouched by constant scrutiny. This is the story of Justice K.S. Puttaswamy versus Union of India, the landmark 2017 judgment that declared the right to privacy a fundamental right under the Indian Constitution. This case didn't just defend privacy, it redefined freedom for over a billion people. This isn't just a legal battle. This is a story about you, about me, about all of us, and the choices we have over our own lives in an increasingly digital world. So, stay with me, because by the end of this story, you might just question what privacy truly means. Picture this: the Supreme Court of India, its halls echoing with arguments and anticipation. This isn't just any case, it's a battle over one of the most basic questions of human freedom, the right to privacy. Can the state truly access every detail of your life without your consent? Or is there a boundary that even the government must not cross? But before we dive into the legal intricacies and constitutional debates, let's take a moment to understand something fundamental. What exactly is the right to privacy? And why was it being questioned in the first place? Think about it this way. Just as you have a right to close the door of your home and decide who enters your personal space, you should also have control over your personal information. In simple terms, the right to privacy means you get to decide what stays private and what the world sees. It's about keeping your choices, your data, and your life under your control. Now, here's where it all began. In 2012, India introduced Aadhaar, a massive nationwide ID program designed to improve access to government services. The program collected biometric data from millions of citizens, fingerprints, iris scans. It was the largest biometric database of its kind. But here's the catch: if the government has all this data, then who is protecting it? And how? The government said Aadhaar was essential for development and efficiency. But many people felt that their personal privacy was at risk. They feared their data might be misused or exposed, and there was no clear promise from the government on how it would be safeguarded. And here's where our hero steps in, Justice K.S. Puttaswamy, a retired judge in his 90s, who was deeply concerned about the state collecting this much personal information. In 2012, he took a stand and filed a petition against the Aadhaar scheme, arguing that it violated a fundamental human right, the right to privacy. For him, this wasn't just a legal fight, it was a matter of personal freedom. Puttaswamy's petition would ignite one of the most historic legal battles in Indian history. A battle that would bring together 9 Supreme Court judges and change the course of constitutional law over the next 5 years. The question at the heart of it all? Does the Indian Constitution guarantee a fundamental right to privacy? And if it does, what would that mean for government programs like Aadhaar? This petition was monumental, leading to a case that lasted from 2012 to 2017, with multiple twists and turns. What started as a simple question of privacy and data collection evolved into a larger debate. How much control should the state have over an individual's personal life? Now, if you are feeling lost in legal terms, don't worry, let's break it down. Under India's constitution, there's a set of protections called fundamental rights, rights that guarantee freedoms we often take for granted, like free speech, religion, and personal liberty. But here's the twist: privacy wasn't explicitly listed as a fundamental right. So, was it protected? The government argued that it wasn't. They claimed that privacy was not a fundamental right, especially if it meant challenging national security or public welfare. But many citizens, including Puttaswamy, disagreed. And Justice Puttaswamy wasn't alone in his fight. Across the country, people began to rally around his cause. The Aadhaar scheme, once seen as a simple identity solution, became a symbol of individual rights vs state power. Would the government respect personal boundaries? Or would it continue to push into private lives without restriction?
Finally, on August 24, 2017, the Supreme Court of India delivered its historic verdict. The 9-judge bench unanimously declared that the right to privacy is a fundamental right under Article 21 of the Indian Constitution, which protects life and personal liberty.
This judgment didn't just recognize privacy, it acknowledged it as a core part of human dignity. It was a victory for every citizen, reinforcing that personal freedom cannot be compromised, even in a rapidly digitizing world. Now, you might wonder, how does this judgment impact you? Well, think about the apps you use, the data you share online, and the devices you own. This ruling makes it clear that you have a constitutional right to protect your personal information from unauthorized access or misuse, even by the state. But, what do you think? Should the government have access to your personal data for national security, or does your right to privacy come first? What would you have decided if you were on the bench? Let me know your thoughts in the comments below. So, what are the 3 main takeaways from the right to privacy case? Privacy is fundamental. The Supreme Court recognized privacy as a core right under Article 21, protecting citizens from unwarranted interference. Limits on state power. The ruling puts checks on government surveillance, ensuring data privacy even within state schemes. A growing digital world needs privacy. With digital information increasing daily, this ruling is a reminder that our personal freedoms matter just as much online as offline. Who would have thought that a retired judge's petition would reshape the rights of over 1 billion people? That's the power of the judiciary and the spirit of our Constitution. If you found this story inspiring, make sure to hit that subscribe button for more insightful stories on landmark cases. And, remember, justice isn't just a word, it's a story, and we're here to tell it.